Hi, everyone. This is Alexander Lim, and welcome to Author Story, where every episode we speak to various authors and various topics of interest. For this episode, I'm interviewing Ilan Wurman, who is a graduate of law school at Stanford University and who also holds degrees in government and physics. Talk about vary. He is presently a non resident fellow at the Stanford Constitutional Law Center and an attorney in Washington, D.C. And there are others. He's also associates with Senator Paul Rand and Senator Tom Cotton. He is also the author of this week's featured book, A Debt Against the Living, An Introduction to Originalism, which you can check out by clicking on the link below. So, Ilan, welcome to Author Story. Thanks very much for being our guest.
Well, thank you for having me.
You're welcome. So, to start off, Ilan, how did you become a book author? What, in other words, is your author story?
Well, so take as an example, as an analogy, when Justice Neil Gorsuch was up for nomination and appointment to the Supreme Court of the United States, tons of people Google searched originalism because they
Okay,
heard Justice Gorsuch was originalist. What is this originalism idea? And we'll
right.
get into that in this interview, I'm sure. But
Yeah.
you might go online and look for a book, and there isn't a short general introduction to originalism, this idea that we should interpret the Constitution with its original public meaning. And so this book, the idea for this book was essentially for all of those individuals who are were curious about how to interpret the Constitution, were curious about these judicial debates, needed an introduction, but couldn't find one. That was the
Right.
situation I was in law school some
Okay.
6, 7 years ago. I,
Right.
heard about originalism. We talked briefly about originalism in law school, but not for very long. I
Mhm.
was curious about it, and I decided to look for an introduction, and I couldn't find one. So
Okay.
this is the culmination of that work.
Okay. So was it like an aha moment and you realize, I got to write this book? Or was it something like, a slow accumulation, slow realization as the years went by?
It was a slow realization. So it started with, again, me striking it out on my own, trying to figure out this originalism thing. What's that about? So I read books on originalism. I read articles on originalism. I wrote a paper on originalism. This
Mhm.
turned into a law review article. Then I wrote another law review article. And at some point, it just dawned on me that I should sort of put together in a general narrative form for a public audience,
Mhm.
sort of the findings and conclusions that I've come to, the findings and conclusions of 40 years of originalist scholarship.
Mhm.
Basically, I did all the reading of the law review literature so that no one else has to.
Yeah.
That's to say you shouldn't read the law review literature. There's
Uh-huh.
some very
Uh-huh.
interesting stuff in there, but I've tried to do the work for you in just 135 pages. So that
Mhm.
it was over time, and then I sort of, I guess, had that aha moment at some point where I told myself, why not write that book that I wish I had had as a law
Right.
student?
Right. Right. So what's the experience like? I mean, I'm assuming that you're a lawyer, so you write a lot of legal briefs and stuff like that. How different is it from, writing a book?
Very different, very
Uh-huh.
different. The style of a legal brief, the style of a law review article tends to be very different than the style that I was trying to obtain or
Mhm.
achieve with this book. So, law review writing is a lot more stilted, I would say. It's a lot more repetitive. It's
Mhm.
all, you have to cite almost every sentence. There's a lot more passive voice.
Right.
And but it doesn't have to be that way. Well,
Huh.
also with this book, I tried to make it as though I were reading the book out loud. I
Okay.
was trying to make it as though it were going to be like a speech.
Right.
And so I've been told that the book is accessible and even fun to
Mhm.
read. Uh, it was fun to write for sure, but I've even been told it's fun to read because I want not just the seasoned lawyer to be able to pick this up and understand it, but I want the advanced college student and the introductory law student and the general reader who just keeps up on these things to be able to read and follow and enjoy it. And so that was sort of the tone. By
Mhm.
the way, I think law review articles and brief writing would be a lot better if it adopted a tone similar to the one I take in this book. I think
Mm.
often it's too stilted and too
Right.
formalistic and too much passive voice.
Right.
But that's a battle that will take a lot longer to fight.
Right, right. And yeah, sounds like another topic for another date.
Yeah.
Yeah. Okay, so about the book, I mean, the title is A Debt Against the Living. Now, I understand that it is Something to do with, I don't know, theories or thoughts surrounding the United States Constitution. Am I correct?
Yes, so the title itself comes from, well, there is this famous letter that Thomas Jefferson wrote
Mm-hmm.
to James Madison in 1789.
Mm-hmm.
And in this letter, this was after the Constitution had been framed and ratified and adopted for the United States.
Right.
Jefferson was in revolutionary Paris. Paris was in the throes of its own revolution. And
Right.
Jefferson wrote to Madison the following:
Mm-hmm.
"The earth belongs to the living," he said. "The earth belongs to the living, not to the dead. The
Right.
dead have neither power nor rights over it. One
Mm-hmm.
generation is to another as one independent nation to another." Now,
Mm-hmm.
Jefferson's letter has been often quoted for this idea that we shouldn't be bound by the dead hand of the past, by the dead hand of the Constitution, that the
Right.
Constitution should instead be this living, breathing document subject to changing interpretations over time. Well, what people forget is that Madison wrote back. Madison replied. And in
Okay.
that reply, Madison said something rather incredible. Madison said, in response to Jefferson, "Well, if the earth be the gift of nature to the living, then their title can extend to the earth in its natural state only. The improvements made by the dead form a debt against the living
Mm-hmm.
who take the benefit of them. This debt," Madison said, "cannot be otherwise discharged than by a proportionate obedience to the will of the authors of the improvements." In other words, yes, Jefferson, you're right, the earth does belong to the living, but only in its natural condition. The Constitution is an improvement of such magnitude, of
Mm-hmm.
such significance upon the natural condition of the world that it can't but form a kind of continuing obligation against future generations. It forms this debt against the living. And the only way we, the living, can faithfully discharge that debt is through a kind of originalism, by a proportionate obedience to the will of the authors of the improvement. So who's right? Thomas Jefferson or James Madison? That's the set piece for this book. And by my choice of title, A Debt Against the Living, you can infer that my book argues in favor of Madison and originalism and the original Constitution.
Right. Right. Okay. Okay. Got that. So before we get any further, I mean, I'm sure there are folks out there who are listening right now who are thinking, this is about the laws, the Constitution, it's boring stuff, old hat, ancient history, dead people, blah, 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 blah. So why would an ordinary person want to pick up this book and read it?
Yeah. Well, so first of all, if you have any interest at all in the Constitution or the direction of the Supreme Court or even modern day politics, as they say, most political questions ultimately become judicial questions, then you should read this book because it's easy to read. I'm told it's fun to read. It's only 135 pages, and this will introduce you to all of these debates and all of these concepts. But more fundamentally than that, we should all be interested in it because remember, the Constitution, yes, it's a law, but it's a law that we the people enacted. It's a law that we the people enacted to bind our governing officials. And because of that, it has tremendous importance to our lives, our everyday lives, the kind of government we have, the kind of political regime it has, the Constitution and how we interpret it touches on everything from the modern scope of federal power to the administrative state, to natural rights and to gay rights, to anything of that sort. These things become, at the end of the day, constitutional questions. So if you've not gone to law school, or if you have gone to law school and just need a refresher or a reminder, here's in 135 pages, and again, I'm told it's fun to read, a distillation of sort of the arguments and the findings about the Constitution and originalism. I should say that the book, to fully defend originalism, I do think you have to also defend the founding. And so the book, in 2 or 3 chapters, also defends the original political theory, the original political philosophy of the founders. So anyone interested in the history of the founding should also be interested in this book.
Okay, got that. Cool. So we've been talking about originalism. Let's get into terms. What is originalism? What is it about?
Originalism is this idea that we should interpret the Constitution with its original meaning, with the meaning the words would have had to the public that ratified it, to the framers that wrote the Constitution. But more fundamentally, originalism is this idea that we distinguish in all cases between two things, between what a law is
Hmm.
and what a law ought to be. that these are two distinct questions.
Mhm.
And this is how we assess the continuing validity of all laws, right? It could be, say, the Alien Tort Statute enacted in 1789. It could be the Defense of Marriage Act in 1996. We first ask, what does the law say? What does it mean? What does it do? And only then do we ask whether it still ought to be the law or whether we ought to repeal it or amend it or so on. Well, the originalists argue that this framework for looking at all law applies to the Constitution itself, which is, as I've said, also a law we the people enacted to bind our officials. So it's the idea that we first have to ask, what does the Constitution actually say? What does it do? What does it mean? What kind of constitutional regime does it create? And then we have to ask whether it's a good constitution, whether it still ought to be the Constitution. These are separate inquiries. And the originalists believe on that first question, right? What does it say? What does it do? How do we figure that out? That we interpret the words of the Constitution the same way you'd interpret the words of any communication intended as a public instruction. So suppose, and I go through this analogy in my book, suppose you found a recipe for fried chicken in your great-grandmother's attic, dated 1789, written in Philadelphia. How would you interpret it? Well, you would interpret the words with the meaning the words would have had to the audience to whom they were directed as an instruction. That means it's public meaning, not a secret meaning. Otherwise, it'd be a very poor recipe. And it means it's original meaning, the meaning at the time, not some modern day different meaning.
Mhm. Okay. Hello, Ilan.
I'm here. Can you hear me?
All right. Yeah, I can hear you. Go ahead.
And so that's the first part of the inquiry, right? But then we have to still ask whether the Constitution is a good Constitution, still ought to be the law, or whether it should be changed. Because maybe non-originalism, this idea that judges can update the meaning of the Constitution over time, maybe that's not a terrible way to do things. You know, if the Constitution is outdated and needs to be changed, and it's hard to change through the amendment process. So I think we also have to defend the founding. We have to defend the original legal content of the Constitution to fully defend originalism.
Okay, so it sounds like it really sounds like getting to original intent, but then more than anything else. I mean, what is the original intent of the Constitution and the laws it springs from?
So I think that's partly true. So there was this old version of originalism was called original intent originalism. The idea that we had to look at the intent of what particular framers thought about particular provisions. Well, this isn't really how we define originalism today. Okay. It's not a very good version of originalism. I think the originalists today would say we look at the public meaning of the words. So the original public meaning of the words, whatever the founders might have secretly intended. Having said that, I agree. How do we figure out what the meaning of words are? Well, they have no meaning without a context. Right. And to know the context, we have to know the reasons for which they were deployed, the problems that created the need to create this constitution or this constitutional provision. In other words, we can look at the overarching purposes and intent of the founding fathers to see why they wrote what they did, and that might bear on what the meaning of the words are. And so in that sense, I actually think getting at the intent and the public meaning are really the same thing. So this is a bit controversial, by the way, in the originalist literature, because original intent originalism is sort of a dirty word. Like, we don't want to look at the secret intent of the framers. And, well, I'm not looking at secret intent. I'm looking at the intent at a high level of generality that they articulated against the Articles, the problems with the Articles of Confederation, that they articulated in the Federalist and the Anti-Federalist papers about how the Constitution would or wouldn't solve these problems. These are all helpful tools to get us to better understand the meaning of what the founders actually wrote in the Constitution.
Okay, cool, interesting. Okay, so originalism. Okay, got that. So, Ilan, I mean, we're talking about originalism as a theory. I'm sure there are other alternative theories out there. Can you just name a few?
Yeah, so the biggest alternative to originalism. And by the way, originalism itself, there are a lot of different schools of thought within originalism, but my aim in the book my aim in the book is to sort of distill them into general findings and conclusions where they all agree.
Mm-hmm.
Now, there is a much bigger variety of non-originalisms.
Mm-hmm.
They're much harder to classify. But
Okay.
the biggest, I think, the biggest version of non-originalism, this non-originalism, is what we would describe as living constitutionalism.
Mm-hmm.
Or another way to describe it is sometimes common law constitutionalism.
Okay.
And it's the idea that precedent matters more than text, and judicial precedents develop slowly over time as new problems arise, as society evolves and society updates. And the text is still important, right? The Constitution is still important.
Mm-hmm.
And we recognize that to the extent it changes, it has to change slowly. But ultimately, judges under this theory have the power, even if they know what the original meaning of the Constitution was or what its original intent was,
Right.
they have the power over time, slowly, to change that meaning, to make, as they say, to make it more adaptable to future circumstances or to modern day circumstances. So that's the alternative, making the Constitution this living, breathing document. There are some other theories of non-originalism out there as well, but these two are by far the most common.
So, Ilan, getting on to originalism, you mentioned the Constitution can be viewed as a living document. Now, how does this point of view compare with originalism itself? What are the how do these two balance each other out?
So indeed, the alternative, to originalism is non-originalism, and there are lots of different non-originalisms, but the most prominent is this, as you say, living constitutionalism, the idea that judges can slowly, in a precedential, piecemeal, common law-like fashion, update the meaning of the Constitution over time. Now, so here are the two alternatives. So the alternative, on the one hand, is that we interpret the Constitution the way we interpret all law, right? And the way we interpret the meaning of any words intended as a public instruction, meaning we look at what the public meaning is and the legal effect that public meaning has in the world, and then that's what the law is until it's been properly changed or lawfully changed.
Mm-hmm.
So there are lots of advantages to this, right? It's consistent with the rule of law, you might say. It's how we treat all law. It's
Right.
consistent with this idea of popular sovereignty. If we, the people, enacted the Constitution, only we, the people, should be able to change its meaning, right, through our elected representatives, through the amendment process or something like that.
Right.
On the other hand, non-originalism also isn't crazy, right? It's not a crazy way to do things, because the non-originalist argument, in its best version, in its best light, goes something like this. They'll say, yes, we grant that there is this thing called the original public meaning. We grant you that ordinarily we interpret laws with the original public meaning. We grant you that we interpret a fried chicken recipe with its original public meaning.
Right.
But the Constitution is different, they'll say. The Constitution is different because not only is it very old and needs to be updated, they'll say, right? Maybe they're wrong, but they say this. It's old, it needs to be updated, and it's very, very, very hard to change through the proper mechanisms because of a historical accident. The amendment process in Article 5 of the Constitution turned out to be a lot harder than the framers had anticipated. It's very hard to amend the Constitution. And certainly the alternative is even harder, this idea of just having a new Constitution, having a revolution in the nature of our government. Right. So barring those things, if the Constitution really is that hard to change, if the Constitution is really that hard to change, but it needs to be changed and it needs to be updated, then non-originalism is not a crazy way to do it, right? It's a way for judges to slowly update the meaning of the Constitution based not only on their independent judgment, but their independent judgment draws inspiration from what the political branches are doing, what's Congress doing, what's the president doing, what do they think is constitutional, what do they think is unconstitutional. These branches draw, inspiration from popular sentiment and are directly responsive to popular sentiment. So if this is a slow way to change the meaning of the Constitution over time to make it more adaptable to modern circumstances, that's not a crazy way to do it. But there are a lot of harms in that too, right? Because first of all, if they're wrong about the Constitution needing to be updated, right, then all of a sudden we have unelected officials
Mhm.
changing our fundamental law based on what they think needs to be updated, even if the people disagree. Maybe the people don't think the Constitution needs to be updated. Then
Right.
does that give the judges the right to do it? What if the way the judges update the Constitution turns out to be a bad way to do it? So there are risks involved with that too.
Mm.
So I think the originalist, to defend originalism against this argument by non-originalists, has to defend the founding. The originalist has to explain that the Constitution the founders gave us is a pretty darn good Constitution. It balances successfully the two competing objectives of a free government. It creates a regime of self-government by which we the people can govern ourselves and decide what kind of society we want to be, politically, morally, culturally, socially, economically. On the other hand, it also protects natural liberty, and these things are in tension with each other, right? Because it's often majorities that infringe on the rights of minorities. Well, the founders gave us a constitution that balances these competing objectives that are in tension with each other through ingenious mechanisms like the separation of powers, checks and balances, the Bill of Rights, the enumeration of powers, and so on. And I really don't know if we could surpass their achievement today. And remember, one other thing, the founders weren't dummies. They knew they were writing a constitution that would have to be enduring. So they wrote the Constitution in broad strokes, right? So the First Amendment applies to the internet. It doesn't just apply to what you write on quills and parchment, right? The Fourth Amendment doesn't just apply to your horses and carriages. It applies to GPS devices put on cars, two things the founders could never have conceived of. The founders weren't dummies. They wrote a constitution that they thought would be enduring with the intent that it would be enduring. And I think they did a pretty remarkable job balancing the needs of a free society.
Okay, interesting, interesting. So let's get on a little bit to brass tacks here, Ilan. I mean, it's all fine to talk about, originalism and Constitution's a living document as something that's could be theoretical and has some maybe some impact on practicality, but how would let's talk about the average Joe or Jane on Main Street. How would originalism impact them in their lives?
Well, think about it this way. What is the impact of having all of these originalist judicial nominees appointed to the circuit courts, appointed to the Supreme Court, if originalism were followed through? This would have a big impact on American life in any number of ways. Now, not all originalists want to go this far, but as originally understood, the scope of federal government power under the Commerce Clause would have to be backtracked, would have to be taken back. Right, so there was this case that's called Wickard v. Filburn, where the Supreme Court basically said the federal government could limit how much a farmer makes wheat on his own farm for his own consumption at home. Isn't that crazy? Originally, the federal government could only regulate interstate commerce. How is this interstate commerce? This farmer, Filburn, was making wheat for his own use on his own farm in one state, wasn't selling it out of state. And the Supreme Court said, oh, that's okay, because by by growing wheat in his own home, he is limiting his demand for out-of-state wheat, which then in the aggregate affects interstate markets, which Congress can regulate. Well, this is the foundation
Okay.
of a lot of modern federal power. Congress gets so much power under the modern day Commerce Clause. So whether it's the regulations of the economy, whether it's welfare, state policies, a lot of these things, if originalism were fully followed through, would have to be limited a bit. They would have to go back to the state governments to do, where there'd be variety. Now, I'm not saying, it would be completely overturned, the modern sort of New Deal regulatory state, but to some measure, this, it would reduce the size and scope of the federal government. And I think that's important to a lot of people. A lot of originalists argue that a lot of the protections criminal defendants get today, like suppression of evidence for an unlawful search, those are not originalist. All it does is let criminal defendants or criminals get off the hook based on these legal technicalities. Historically, as an original matter, let's say a police officer conducted an unlawful search of your property. Well, you could sue the police officer in court and get money damages, against them, trespass damages, other sorts of damages. But if they found incriminating evidence, then that incriminating evidence was admissible in court. So I'm not saying that those things are necessarily good or bad as a matter of policy. And certainly Congress or the states could recreate these rights for criminal defendants, which I think they probably should. But the point is, originalism matters. It matters to the modern scope of federal power. It matters to the scope of the administrative state. It matters to the scope of economic liberty and how much the government can regulate your economic liberty. This has impacts all across the country for all sorts of Americans.
Okay, so really, this is not just so originalism. This really not just a vague theory, a vague thought, just something that it would be nice to have or something like that. This really has a big impact on the way people would live their lives, or on the laws that are passed and how these laws are upheld, and stuff like that. Then.
I think that's exactly right. And think about it this way. Every two-term president gets to appoint about a third of the entire federal judiciary. And if President Trump is elected for a second term, he has the ability to basically reshape the judiciary into an originalist judiciary. And this could have a huge impact. It could also have an impact, on how we perceive of as rights, So it may be a matter of, I don't think the gay marriage, the same-sex marriage decisions are going to be overturned or anything like that. But, it's not implausible in the future for maybe judges based on originalist grounds to say, look, we support same-sex marriage, but it's a democratic choice left by the Constitution to the people, precisely because the founders knew we would evolve and progress over time. They didn't constitutionalize these things. They left them for the people to decide. And maybe, we have to go back to something like that. I don't really see a Supreme Court reversing that decision. But the point is, it has the potential to impact all of us in many different ways and in many different facets of our lives.
Okay, all right, very interesting. So that argument right there, that sounds to me like a very good reason to check out this book on its own. This does have impact on people.
It does, and the best argument, of course, is that it's only 135 pages and only $15 right now on Amazon.
All right, cool. Okay, so Ilan, let's say you come across someone who's who has an interest in the Constitution, philosophies behind it. But the thing is, he's brand new, may or may not know about these. And say you only had enough time to tell this person one thing about originalism or relationship to the Constitution. What would be that one thing you'd tell that person?
I think I would tell them that originalism is not this narrow-minded concept focused on the world, focused on a world that's long dead and gone. Originalism is a capacious concept. The Constitution that the founders gave us may be dead in the sense that it's not a living, breathing Constitution, but the democracy that Constitution creates is a living and breathing democracy that allows us over time to progress and evolve and let our ideas play out in the realm of democratic politics, which is how I think it should be.
Okay, interesting. All right, cool. So, in the closing minutes of this interview, Ilan, are there any last words of wisdom you'd like to share to inspire our listeners?
Just that the founders were remarkable people and their insights have remarkable endurance to today. You can read the kinds of problems balancing self-government and against liberty that they tackled, and these same problems apply today. And I think when we look at the nature of the problem they were trying to solve, it's really remarkable what the founders accomplished. Yes, they weren't perfect. And yes, we've progressed since their time. And a good thing we've progressed since their time. But I think we've done so largely because we stand on the shoulders of giants. We stand on the shoulders of what came before. We stand on the shoulders of their achievement in the Constitution. And it's an achievement worth reading about.
Okay, cool. Got that. So great words of wisdom right there, Ilan. So,
well, thank you.
You're welcome. So in closing then, the book is A Debt Against the Living, An Introduction to Originalism. The author is our guest, Ilan Wurman, and you can find it on Amazon. So Ilan, thank you very much for being on AuthorStory. Thank you very much for shedding light on this very enlightening topic.
Thank you for having me.
Cool. So everyone, I invite you to go ahead and check out A Dead Against the Living, as well as subscribe to our channel if you want. Bye for now, folks. I'll be back next time on our Author Story Weekly interviews with another inspiring author.